Mike, what do you got?
Here's the question. As you obviously, as you know, in order to arrest someone, you have to have probable cause, a fair probability a crime has been committed by this individual. However, for qualified immunity, all you need is arguable probable cause because of Malley versus Briggs. Here's my question. To detain someone briefly, you have to have reasonable suspicion. Does that arguable reasonable suspicion logic apply to a brief detention the exact same way it does to an arrest for the civil liability aspects of qualified immunity?
I mean, yeah, right. I mean,
say yes,
yeah, I
right?
would say yes. I think it's a, are you aware of any cases that have addressed that issue?
No, and that's why I'm asking, is because I've done extensive looking for that, both the old way as well as artificial intelligence, and I have not found a single case that will.
I think it'd be comparable. I mean,
I think the logic
as long as there's
applies.
a conversation, right?
Now we do have some people on here that don't understand what arguable probable cause is. Mike, do me a favor, because Mike is one of the smartest people I know, by the way.
I like listening
Mike,
to
do me a favor. Please give a Reader's Digest for cops about what is arguable probable cause versus regular probable cause.
Here's the difference. As the U.S. Supreme Court has instructed in Malley versus Briggs, an officer is entitled to qualified immunity if officers of reasonable competence could disagree on the issue of probable cause. The issue is not whether probable cause existed, again, for qualified immunity, civil liability reasons.
Yes.
Rather, the issue is whether arguable probable cause existed. So therefore, it is a lower threshold than probable cause itself. And again, this is for qualified immunity, civil liability. It is not for whether or not the arrest is valid.
That's right. So if you don't have probable cause, then the guy walks, right? Or you lose your evidence. If you don't have reasonable suspicion for the detention, then you have a fruit of poisonous tree type stuff.
Right.
We are talking about paying money, essentially, right, Mike?
Yeah, civil liability.
Civil liability. Now, the one thing, in arguable probable cause, they talk about ultimately it's still a reasonable officer, right? Could a reasonable officer still believe that there was probable cause? And it's just another relief valve, and quite frankly, which I agree with, it's another, philosophically, it's another relief valve to reduce the amount of liability for an already a litigious profession, right? I mean, you got cops doing the Lord's work out there. They make a call. They think they have probable cause. And Mike, you correct me if I'm wrong. They think they have probable cause. At the end of the day, the court, throws out the case because, hey, officer, you made a mistake here. You did not have probable cause for X, Y, Z. And then the defendant turns around and becomes a plaintiff and sues you. And that court, the civil court, says, well, hold up. I know the criminal trial didn't go forward, but still, it's arguable. Like, it wasn't like the guy was a dope.
Correct.
I mean, he still thought that he was. Yeah, he wasn't a
disregard.
Yeah, it's right. And some cops choose good faith, but which is not really what we want to talk about. But it's like, hey, I still think an officer in your shoes a reasonable officer would have thought you had probable cause. Now, Mike, this is definitely your realm because you do a lot of civil work.
Let me add to that just real briefly. The difference is in qualified immunity, whatever doctrine it is you're trying to establish for reasonable officers must be beyond debate. Therefore, if two reasonable officers can debate it, the officer prevails against qualified immunity. That's the distinction.
Yeah, exactly. But it's reasonable officers beyond debate. Sometimes Mike, and the reason I bring that up is because I have heard cops or sometimes lawyers, not too many times, but they'll say, oh, if any officer out there can say that there was probable cause, whatever, we win. No, it's not.
That would be all the time.
It'd be any dope out there. Some cops should not be cops, right? They don't know, they don't appreciate the law. It's any reasonable officer. So there's always that standard of reasonableness, which of course, what's reasonable mean? It means what the judge thinks.
Yeah.
I mean, it means what the rule of nine, right? What's the ninth Supreme Court justice say?
There you go.
So Michael Brave put in the Briggs case there. And look, this is not my forte, but I cannot think of a reason why arguable reasonable suspicion would not be a viable doctrine. In fact, maybe even more so because reasonable suspicion, quite frankly, is even more debatable than probable cause.
Very true.
I mean, at least it's like a fair probability of crimes being committed. Reasonable suspicion is definitely even more arguable.
Yes, inherently.
I
mean, it's what it is.
Exactly. Oh, look. Okay, so all right. So look, I wish I had more for you. I definitely don't have a case. You would have found it anyway, but I think it's a great discussion.
Yeah, I like it. Yeah, thanks, Mike.
All right.